The Supreme Court of Pakistan is the apex court in the judicial hierarchy of Pakistan. Established in accordance to the Part 7 of the Constitution of Pakistan. It has ultimate and extensive appellate, original, and advisory jurisdictions on all courts involving issues of laws and may act on the verdicts rendered on the cases in context in which it enjoys jurisdiction. In the court system of Pakistan, the Supreme Court is the final arbiter of legal and constitutional disputes as well as final interpreter of constitutional law, and the highest court of appeal in Pakistan. In its modern composition, the Supreme Court is incorporated of Chief Justice of Pakistan, 16 justices and 2 ad hoc who are confirmed to their appointment by the President upon their nominations from the Prime Minister's selection based on their merited qualifications. Once appointed, justices are expected to complete a designated term and then retire at 65 years old, unless their term is terminated through resignation or impeachment by the Supreme Judicial Council. Resulted in a presidential reference in regards to the misconduct of Judge. In their discourse judgment, the justices are often categorized as having the conservative, textual, moderate, and liberal philosophies of law in their judicial interpretation of law and judgments. 1915 is to 436. The Supreme Court has a permanent seat in Islamabad and meets at the Supreme Court building at the Constitution Avenue. In 1861, the British government in India enacted the Indian High Courts Act that created the High Courts in all over the Indian subcontinent in various provinces while abolishing the Supreme Courts Calcutta, Bombay, Madras, Lahore, and also the Panchayati system in autonomous presidencies. 234 until the enactment of the Government of India Act 1935 in 1935 that created the Federal Court. These new high courts had the distinctionary powers of being the highest courts for all cases. 235 to 236. The Federal Court had wide range of jurisdictions to resolve disputes between the provinces, presidencies, and the Government of India Act 1935, often hearing appeals against judgments of the high courts. 44 to 50. After the independence of Pakistan as an aftermath of British partition of India in 1947. The Federal Court was also partitioned between India and Pakistan as Justice Sir Harilal Kania became the first Chief Justice of India and Justice Sir Abdul Rashid becoming the first Chief Justice of Pakistan. 294. While the tradition of British law culture continues to remain an integral part of the judiciary, the modern existence of the Supreme Court of Pakistan came when the first set of the Constitution of Pakistan was promulgated on the 23rd of March 1956. 10 to 1124-26. The ratification of the Constitution of Pakistan re-established the Supreme Court in 1956, replacing the name, Federal Court, to Supreme Court. Initially had its seat in Karachi where the Sindh High Court exists now. In successive years, the Supreme Court was moved to Lahore High Court until the Supreme Court was permanently moved into its new building constructed in Islamabad in 1964. Although the Supreme Court was established pursuant to the Government of India Act 1935, the modern structure of the court was re-established by the second set in 1956 and restructured by the Constitution of Pakistan in 1973, where a significant part of the Constitution is dedicated towards the restructuring of the Supreme Court. The Part 7 of the Constitution ranges from Articles 176 through 191. Deals with the powers, composition, rules, and responsibilities of the Supreme Court. These articles concern the Part 7 of the Constitution of Pakistan reconstituted the composition of Supreme Court and the High Courts, but it does not specify the number of justices to be served in the Supreme Court. Qualifications to be served as a Supreme Court justice are strictly imposed that are based on merit, personal intellectualism, and experiences as a judge in the High Courts. In 1947, the Supreme Court consisted of a Chief Justice and 6 senior judges from Sindh, Punjab, NWFP, Balochistan, and East Bengal. 94 to 95. Over the several successive years, The work of the court increased and cases began to accumulate, leading the Supreme Court requesting the Parliament to increase the number of judges. As the number of the justices has increased, they sit in smaller benches of 2 or 3. However, coming together in larger benches of 5 or more when required to settle fundamental questions of law. 16 to 17 The nomination of justices in the Supreme Court comes from an executive selection made by the Prime Minister based on judges' merited qualifications, personal intellectualism, and experiences as judge in high courts. The President then confirms the nomination summary and eventually appoints the Chief Justice and judges in the Supreme Court. The Constitution states that a nominee is not eligible unless he is. Since the 1990s, the nomination and confirmation process